good, thanks. And you?
Yeah, no, good, very, very good. Thank you. Thank you.
Lovely. I'm just going to introduce the roundtable to those who may not be aware of what it is. So this is a bi-monthly event that we hold between all local employment lawyers and HR professionals in the area, more for the benefit of our benefit of our employer members. It is recorded, it will be shared, and you can listen to it in your own time. And we generally tend to discuss contemporary topics or any questions, burning questions that anyone in the community is struggling with, and they might have sent it to us before the roundtable. I know today's event is about artificial intelligence and whether it's a boon or a bane for employment law professionals and HR professionals. Um, I will start that discussion in a bit. We're just waiting for a few more members to join. But in the meantime, we've got one question that's come in. If everybody is all right with that, can I just raise that question now? Okay, so this is about a director of a listed company who has resigned, but it turned out that this director of the company, just because of various issues that are ongoing, apparently, all the directors voted a few months ago that they would defer taking their salary. Things have gone a bit pear-shaped. The director has since resigned with immediate effect and is now demanding that all dues be paid with immediate effect. Now, the question that I've got is, given the vote and the resolution that was passed to defer salary payment, is the board obliged to uphold that resolution? Or given the more recent resignation and the requirement to, or the demand to pay all dues, are the directors more bound by the latter? That's the question. Hi, Gemma.
Hiya. I've come in on half of something, so I'm going to keep quiet for this bit.
Sorry, we just said
No,
we're
that's right.
starting I've just got one question here that's come in, so
Okay.
we're just going to raise that question, but then we're going to get on to the discussion of AI
Okay.
in the remit. So yeah, it's more about a listed company and one of the directors of the companies. Just to repeat the question, they passed a resolution I think 3 or 4 months ago. It says for May. So yeah, they've passed a resolution to say all directors are happy to defer taking salary and any payments owed to them. But more recently, one of the directors, because matters have gotten quite sour, the person has resigned and is now demanding that all dues be settled with immediate effect, or basically in the immediately next, in the pay run later this week. So the question is whether the earlier resolution still holds, in favor of which this director who has resigned also voted, or are they bound by the recent demand from this director to settle those dues? Or does there have to be, I'm thinking, does there have to be another resolution or a vote passed for all the directors to decide what should be done here?
Can I just ask, the thing that I'm sort of wondering is, obviously the resolution was that the directors agreed to defer their payments, and not that they wouldn't receive payment, but just defer until, I guess, was there a time frame involved of how long that would be in place for? It sort of seems to me a little bit odd that, or the director that has resigned, that would be expected to not receive anything at all. They didn't agree, they were not getting their salary at all, but just that it would be deferred. First thing that comes to my mind.
So what has been added there is that they haven't been taking any payment. These directors have not been taking any salary payments for the since May. So the wording here is the resolution was to defer any payments owed to them until such future date when it is agreed as to when it's going to be paid. And in the interim, they haven't received any salary payments. But I agree with you. I think if somebody's resigning and they've mentioned explicitly in the resignation letter that they wish to get all their dues, or at least, all their dues paid to them with immediate effect, I feel that would, that being the more recent communication from this director, that would hold, sort of over, that would almost kind of be the governing factor rather than the resolution that was passed 4 months ago. in deciding whether he should be paid or not.
Yeah, like I said, I think for me, it's a question of the director. You know, this obviously started in May. It's been a few months, not been paid, and no one's been paid. But there would be an expectation, I would imagine,
Yeah.
that pay will come. So I don't see why the director wouldn't have that expectation now that he's resigned, or he or she.
Does the company's financial situation have a bearing on what is done? If this I am aware that this company, because they've shared that with me, and they've said, financially they're not in a strong place at the moment.
I don't
They're
think
owed.
Sorry, Sandhya, I don't think the financial situation of the company has a bearing on the underlying liability, but it might very well affect the and impact on the expectation and the underlying agreement, because it doesn't matter if it's parlous or cash rich. If it's a legal liability, that's made out. But it's interesting because the director can't have any claims for breach of contract or unlawful deduction of wages insofar as this has been agreed. So
Yes,
and providing the resolution was agreed in writing,
it is.
the
Yeah.
statutory framework is satisfied
Yeah.
there. So it can't have been any part of a claim for constructive dismissal. So absent those points, the fact he's resigned is a different issue. The question, I suspect, is whether the resignation and or rather the termination of their position triggers or is an intervening event, and it triggers now the liability to make the payment.
Yes.
Because at this point, notwithstanding the previous agreement, surely he is now a creditor of the company.
Exactly.
And
Yeah,
at that
this is
point,
what I was thinking, whether this recent communication has a bearing over the resolution that was passed earlier.
yeah,
And you
I mean, my take on it would be, at this point, it's not so much about an employment entitlement, because we're talking about post-employment issues, and he's simply on the outside, assuming his employment has ended, and he's not just
with immediate effect. Yes.
Yeah. So because absent any counterclaim that the company might have for failing to give notice, it seems to me he's a creditor, and
yes.
he can now say it's all about the underlying resolution, isn't it, and the agreement that was reached.
Yes,
So
exactly.
there's a huge amount that we don't know, but my take on it would be the case he would put forward is that he is now no longer bound by that resolution because his employment and his position of office holder has ceased. He is now in a different capacity and wearing a different hat. He's due the payment because the payment is due, albeit as an emolument referable to his contract at the time. It's an accrued due debt. It's immediately payable. And depending on the sum, and I'm sure it would be over this, it would be capable of being put forward as a statutory demand.
Yeah. Interesting. Okay.
And I don't know how the company, and I'm not trying to give advice, but I don't know how the company would resist that, because they can't say you'll never receive that payment. They would have to ask.
The resolution has said that they will be of course, this is in relation to salary and dues owed to the directors in the capacity of a director, but you're right. I think once they go on to being referred to as a creditor, then I suppose any rules that they have in relation to settling creditors' dues, that might kick in.
Yes, the devil's in the detail, as I say, and of course we don't know.
It is in the detail, and
in terms of the resolution,
I agree.
but I suspect both sides would have thought it was incumbent. It was a term precedent to give effect, business efficacy to the terms they've agreed.
Yeah.
That they're talking about during the employment. This is what we're
exactly.
Post-employment,
exactly.
seems to me it's crystallized and it's a liability.
Yeah. No, thank you. I think there's a few things for them to think about, but no, thanks a lot for that.
I could be wrong. Wouldn't be
in
the
these
first
situations,
time.
which is why I put this question across, because it was my first time, and I I thought, okay, I'll just put it out, but it's good to know that it's your first time too, Chris, especially with your years of experience. Okay, I think if everybody's all right, does anybody have any other questions they wanted to raise before we talk about our topic for today? Rose, hi. Okay, in
Hi.
which case we'll just kickstart the discussion today, which is artificial intelligence, and what is, it'll be good to understand from you any examples that you've come across in your day-to-day work of clients using this, and whether you really think it's a bane or a boon within our line of work, and of course with reference to employers. So over to you to share any examples or insights. Silence. Just to help matters, I've got one example here. So we, with clients, we have increasingly seen that there is, they tend to use ChatGPT, and particularly for things like job descriptions, where they just want assistance in creating a quick job description. And of course, then that's all vetted and that's all fine. But I had one situation where a client, this was before they became a client of mine, but they were using ChatGPT to understand employment status. So whether somebody would be a worker or an employee. I think contractor status was very, very sort of cut and dry, but they were trying to understand from ChatGPT whether somebody would be a worker or an employee, and they were getting themselves into a complete muddle because it just wasn't able to dish that out, so to speak. So that's been one of my experiences, that I think for employers, they need to have more clarity. It's a tool at the end of the day, and they need to have more clarity on really where it would be a safe place to use such a tool, and areas where they must actually steer clear of using ChatGPT. Would you agree, or has that been your experience as well?
I think I'd agree with that. Trying to ChatGPT legislation and get AI and legislation, particularly in the current circumstances that we're in, where it's all, we know that it's going to change, and what that looks like, we're still waiting to see. I think that could be really dangerous for employers, and I think we could find ourselves up against some challenges where employers are saying to us, well, ChatGPT has told me this, or AI has told me that, and you're going, but that's not what it is in practice. And my concern would always be about how quickly AI is updated with the latest legislation.
True.
I think we had a brief chat about this the other day, Sandhya, didn't we? I said to you that I'd heard somewhere that unless you're using the paid-for version of ChatGPT only has information up to 2021. So you kind of think of all the changes that have come in since then. If people are using those,
this was a paid, these are paid versions, but I just think ultimately ChatGPT is just going to regurgitate guidance or information based on what it's been fed with.
Yes.
But there was another similar example, but this was more kind of going into GDPR remit, where this is obviously not one of my clients, but something that came up in a forum again, where this business was using ChatGPT to screen candidates. So they were feeding all the data that they were receiving in terms of, applicants' information into ChatGPT, and using that to screen candidates based on certain criteria that had been fed into ChatGPT. Now, when I was talking to a GDPR, a colleague of mine, a specialist, and she was of the view that actually, and I suppose as HR professionals, we come across this, you are required to have informed your candidates that you are feeding their data into AI or a ChatGPT, or an AI tool like ChatGPT, in order for it to assist with selections. Because as far as your candidates are concerned, it's human beings, the company's HR or the company's, leaders going through the selection process or doing the selection process. if you haven't informed these candidates that their data is going to be fed and been sitting in in an AI tool, then that is a breach of GDPR. So that's another area which I think some employers are already falling foul on, unbeknown to them, that it's not as straightforward as just entering data into AI and expecting it to give you the results. It's not,
I think
you
there's
could be breaching
also a
some laws there.
difference. There's a difference between feeding it into ChatGPT, which is not a specific selection tool, and using a specific AI selection tool as part of your recruitment processes. Those two things are quite different, because if you just shove it in ChatGPT, it's in the public domain, not just within that particular AI tool. So that creates a much wider problem, I would say, than just getting their permission to use AI to select from a pool of candidates.
Yeah, I agree. So again, something to, when putting out an advert, the way to get around it is, I suppose, when you put out an advert for a role, employers need to be very clear if they are going to be using specific AI tools as part of the recruitment process for screening, but also explain, like you've just pointed out, Roz, whether it's a generic AI tool, whether it's something that is purpose-built for recruitment.
I think you get that quite a lot. Certainly somebody that I happen to be chatting with outside of work, they work for a really massive company, and they recruit pretty low-level roles, which you get multiple,
Yes.
thousands of candidates for, or applicants for, and they were using AI to select from those, because obviously if that be an incredibly time-consuming person activity, so they were feeding it in. But I think most of the clients that I work with are very small, so they just don't need it for that particular function. They might use it incidentally, for example, if they wanted to write a job description or something. But I haven't had many clients come to me and say, what's this AI thing all about? How can we use it in our business? Because they just don't have they're just not big enough to kind of need that level of assistance.
Yes.
I don't think it's a kind of a volume thing potentially in some ways, but certainly in some areas, for example, the recruitment area would be one.
Yes. Any other pointers? Anything else that anyone's come across where your clients might be using it?
Well, I was just going to say, it's interesting because I think there's obviously tools coming from AI as well. So even just on my meeting screen, I've got AI companion down at the bottom, as I'm sure you all have, that gives the meeting notes and summary and action points and all of that sort of thing. So I know we've had discussions on this forum before about the recording of disciplinary minutes and where we, that sort of thing.
Yes.
So where does that border with AI recording and giving a summary of meeting minutes and all of that sort of thing fit with that? I think at the time we all agreed that none of us liked the idea of having meetings digitally recorded. So if people are then using AI to record meetings, that kind of still fits within that same thing. But actually it can bring some interesting tools, because if you're just having a chat with a client, it could be really useful to have kind of action points recorded from a meeting.
Yeah, and I do know that there is actually, I'm trying to remember the name, Gemma, you just caught me out there. And there is a specific web, I'll put the details here, but it's an AI tool that is used specifically only to minute HR and employment law or law meetings, and so that, and it's made very clear that once the minutes are produced, like a written copy of the minutes are produced, it's just going to be taken off the system. It's just going to come off the system. I will post the details over here.
Yeah, I'd be interested.
But at least that's what we tell our staff, that it's going to come off. Whether other businesses do that and whether they just leave it there, I do not know. I can't speak on that. But from my point of view, I just take it off once I've produced the hard copy.
Yeah.
I will pop it in the window
past.
in a minute.
Otto,
Yeah, I'll put
Otto,
it.
have you used those?
Otto. Yes, I've heard of it, but I haven't used it.
I've
Terrible.
used it.
Okay.
I've used Otter, but I was introduced to a new one, which is called,
Oh,
God,
yeah.
I think it's called Fathom, and it links in with whatever video calling tool you use, software, and it can produce notes. So I think there's again a kind of it's maybe something you need to specify in terms of saying we're going to record this meeting to create a transcript, rather than we're going to record this meeting and your voice will be captured forever as you know, as part of the meeting notes. Because if you're just using it to make sure that the conversation is captured in writing, then I think it presents fewer concerns, I would imagine, than people sort of thinking that there's a sound recording of the meeting somewhere. I don't know what everybody else thinks, but it seems less big brothery.
I think it is something you have to be careful of. We've had a couple of instances in our firm where, well, I've had one, and I know colleagues have, where a client meeting on Teams and actually a sort of a third party unexpected, well, it wasn't a third party, it must have been some kind of recording AI device appeared as a guest sort of at the entry stage, which I didn't allow, but it turned out it was some kind of AI recording device that the client hadn't raised with me in advance. And, we had a discussion as a firm after about what our policy would be. We can't let people just be sending in these whatever AI bots they are to record, and we don't know what then happens. Is it on ChatGPT? Is it sort of one that information goes elsewhere afterwards? We have no knowledge of what's being done with it. So we've now got a sort of policy whereby we won't, we'll say to clients if they do want a particular recording done in a different way to how we'd normally write notes, we will arrange that at our end rather than allow them to come in with a piece of software. We just don't know enough about it and where it's going. What it's used afterwards is, I don't know if anyone else has had that, but yeah, it's caught us unawares a bit.
So I have just posted rev.com, which is what is sort of used quite commonly in our line of work, and yeah, it's proved to be useful. But going back to Antonia's point, I think the nearest I've come to something like that, Antonia, is where people will just say, I'm just going to record this meeting. I know yours is slightly different, where you didn't even get that information or get that notice, but people just come to the meeting and say, I want to record this, I'm going to switch on my phone. And of course, then you go, well, no, we don't agree with what you're recording. Minutes are going to be taken, and you can take your own minutes. But now with this kind of a tool, I think it's there have been challenges when I tell a staff member that I'm recording it only because it allows for more free flow of conversation rather than me having to peer down and keep typing while they're speaking. Some are quite okay with it because I tell them that it's just going to come off the app after I've generated the notes. I still get resistance in some cases where they will go, not having it. And that's okay. That's okay. And I'm just happy to just type. So I think one has to just, from what I have seen, we just work with the employee and go with what they'd like or prefer. Yeah. Any other interesting insights?
I mean, for us, it's all quite new still. I'm not having a lot of issues coming from clients about problems yet, though I anticipate them. But, from our point of view, we've now got a tech committee at our firm because we're trying to get our heads around, first of all, how we use it to help us in our job as lawyers and how we can do that safely, preserving obviously confidentiality key, because everyone got very excited about ChatGPT to start with, but of course that's a very dangerous tool to use unless you're going to completely anonymize and put fairly basic questions in. I mean, a Microsoft Copilot, I think, is a platform on top. It uses ChatGPT, but the information you put in doesn't go out into the nether. You have some kind of control over that you don't have. But anyway, that's a whole set of concerns we have sort of in-house about what we're going to do. Then in terms of trying to deal with clients to ensure that they have policies in place to deal with what their use is for their employees within the firm, how they're going to use, are they going to have training in AI, what they can use it for, what they can't, what types they can use it for, what they can't. But I think a lot of places, the smaller employers are a bit like us, trying to first work out what we're going to use for what, by what mechanism, and what's the safest for our firm. And then, of course, there's all the data protection that you've referred to, and the confidentiality, which is key. I haven't come across so much yet, but I know it's out there. Companies using it for recruitment, perhaps performance management, absenteeism, and the risk then, well, making it absolutely clear that there has to be humans monitoring to look for any bias that's coming out as a result, because I hear that's rife, but I've not actually had that as a claim yet coming in from a claimant, or I'm not had it as an issue yet brought to me by an employer, but we're all waiting, because I'm sure they'll be on their way.
Yeah, bias is a big thing. The other thing where I came across, I just was reminded of this, clients who have creative work that they create for their clients. So, for example, visual arts, creative designing, and we've had to include in the policy to say, if you're found to have regurgitated AI-related work, and basically a bit like plagiarism, but in artwork, then it could be cause for a disciplinary. It's got to be your own work. It just can't be AI generated. But I think right now, the question, because it's such a new area, the struggle was whether you would refer to that as gross misconduct or misconduct. And it was leaning more towards gross misconduct, because you're almost kind of leading a client to believe that something is yours when it's not, which is kind of another word for fraud. And so my take was that it would fall under gross misconduct, and it'll just be good to understand what you think about that. But that was a new area that I just was caught out, and I had to really think a little bit about how to put that in the policy. Yeah, that was another new area. Redundancy calculations, I guess, is another one I've seen clients use it for. But that seems more straightforward, because you're not putting in any names necessarily. You're just asking it to calculate the redundancy amount. So that seems like a slightly safer bet. Yeah.
We've used it for some great articles. It can write, but I just feel whatever you use it for, we're finding as we're navigating our own ways, you've got to know what you're talking about before you use it, certainly with ChatGPT, because it comes up, it misses things and it gets things wrong, and it hallucinates a bit, makes things up. So you've really got to be using it as an aid from a position of knowledge, and with, particularly with junior staff coming in and, trying to work out as a firm, we don't really want people over relying on it at an early stage in their career when you've got to go through the learning yourself and comfortable with your knowledge, because you've got to see it may help, it may do some of the base work, but you've got to know where things are right and wrong. And I think that's really the key about using it, and to advantage, to help, but not over relying and not understanding it's fatal, it gets things wrong. So people have got to be monitoring and checking the results of it. So yeah, that's just my take at this point, early stage.
Yeah, I think you can use it to start drafting something. So it's easier than starting with a blank sheet of paper. If you put in what you want your article or blog or whatever to be about, you can put in the basic, information, and it gives you something to work with, and then you can change it. Because anytime I've tried something as a bit of an experiment, it comes out with something that just is not the way I would write, because it's all very over the top and Americanized, a lot of it. And it's just, so I just end up rewriting it. But it's kind of easier to do that than it is to start with a blank sheet of paper, I suppose, and start from scratch.
You touched upon this really interesting point, Roz. So I was having a chat with another colleague, and we were talking about how these days it's very common for job applicants to use AI to submit an application. Okay. and I always say to clients, always pick up the phone and have a screening, phone screening stage, because then one, you exclude all the sort of ghost candidates. But two, now with AI, we find that it's a great way to suss out whether somebody has used AI to submit their application, exactly because of what you said. The language that is used in the application is so not the way they speak. And if you just were to keep, listen to what they're saying and read and really catch them out on specific points, you can actually tell whether it's been AI generated or it's their own application.
Yeah, someone can sound like they're the most articulate and educated person on the planet because of an AI tool, and then when you talk to them, it's like you're meeting a different person.
Yeah,
That's certainly
and
been the
that's
case
something
for
that's
me.
come out.
It's about what I write.
Yeah, that's another one. But gosh, there's so much to look out for, and I still can't. I think there are good and bad elements to it, but like Antonia rightly put it, and you've just said, I think one has to just have just keep an eye on it and vet it, no matter what it generates in our line of work, I think.
And in terms of recruitment too, I mean, I think I've seen a few adverts now where it depends what you put. I mean, sometimes it could be seen as using your initiative to do your research and use AI and perhaps to write a better letter than you might write. But I mean, it really depends on what the position is. And I think it's just up to the employer being upfront about what they will accept and not in terms of people putting forward their applications. And I have seen somewhere it says expressing that it is okay for people to use their initiative, but they would expect that to be an open disclosure, of that, what they put together, what they might have used for a particular test or an application or done a piece of writing or whatever it may be, because it's all out there. So actually using it may be a sign of initiative and maybe the sort of person you're looking for in a particular role, but it's taking away that fraudulent element, the sort of deceit, hiding behind something and pretending it's yours. So I think that's something too we have to think a bit about.
So are you saying, just so I understand this, Antonia, so are you saying that when you put out an advert to invite applications, you make it clear in the advert to say, if you are using AI for specific elements of your application, then you are required to be explicit about where you have used it. Is that what you're saying?
Yeah, I mean, I haven't seen that expressed, but yes, that idea really, that or if you're expecting none at all, it's got to be completely your own, that you make that clear as well. Because if you don't, and then people are using their initiative, particularly if perhaps somebody has a disability or something, with reason why they perhaps might be using an AI tool, and that could become problematic then if you just dismiss that out of hand.
I think that's a really interesting point, Antonia, actually, because I've got a couple of tech clients I work with, and they very much kind of embrace the idea of AI. And, if someone used their initiative to show what they could do and pulled the tools, I think it's back to that kind of submitting something as it comes or using it as a tool to create something else. And I think some companies, it's for AI at the moment, it's very much you're either kind of completely on board with it, or you're totally against it, or you're not really sure because it's new and it's changing. But there are some companies out there that are massively embracing it and just going, okay, let's roll with this, and how can we use it, and using it in a positive way. And I think, if you had a company that was kind of embracing AI, that wanted someone to go in and do an AI function within their business, then actually you might kind of embrace someone that had kind of gone, yeah, okay, I've used AI to do this. This is what I'm demonstrating what I can do with it.
Yeah, it's all about transparency, isn't it? And then eliminating that fraud element. And then, as you say, the companies can choose whether they think that was initiative, or if they want people to be complete, independent thinkers and not have any prompting tools.
I did have sorry, I did have
go
actually
ahead.
they didn't become a client, but it was an interesting question from somebody who when she'd got on to some graduate scheme, she had done a lot of research and had managed to go into a number of forums where candidates, successful and unsuccessful, had all put in a lot of information and had sort of come up what they felt the correct answers were to the tests that were done as part of the interview process. And she had got the job, but it was a couple of years later, and the company now had this software that was able to screen, this AI to screen everyone's results, and they were going through they were going back a number of years, and she had received a letter to say they were going to be investigating and possible disciplinary because the results that she had through their goodness knows what kind of process had targeted her as something that she could not have got all those answers in the way she did unless she had relied on, they were suggesting it was cheating, but her argument was that she hadn't done any cheating. She was just doing everything that a candidate would do to prepare, using whatever she could out there on the internet to prepare for this exam. I mean, she didn't become a client, so I didn't have to advise her, but it was an interesting, proposal. If I had, we'd gone
Yeah,
forward
so
with
that would have been when it was all very new and people wouldn't have had that disclosure on their, the
yeah,
relevant information about the process, saying what isn't allowed, because
yeah,
people didn't realise it could be used for that kind of thing. So how
yeah,
fair would it be to apply that
yeah,
retrospectively 2 years down the line?
yeah.
Mind you, I had a similar conversation with a client just 2 weeks ago where this was an employee anyway on their way out, and the employee has now resigned since. But just 2 weeks ago, when everything was just not looking great, this employer told me that the employee's CV, again, she was hired about 4 years ago, said that she had graduated from a specific French university and had some qualifications in French. And possibly she had, I don't know what construed there and whether she had just mentioned it, but something came up in conversation more recently. And when the employer mentioned saying, "You speak French, don't you?" And she goes, "Don't know a word of French." But her CV at the 4 years ago did at least claim that she could speak basic French and had graduated from a French university as well. So again, I just wonder whether, yes, you can, how far do you take it in terms of getting AI to verify these things? And you just going back to your previous point, Antonia, where you said if somebody's got a disability and they are allowed to use AI, fair enough. But equally, how would we, what sort of reasonable adjustments do you need to make now for them to be able to do their day-to-day job? Yes, you can use AI to submit your application, etc. But again, then you're opening that discussion with occupational health to say, can this person, to what extent can they use AI to do their job, etc., which then brings back to question my earlier point. In your policy, we'd have to be careful about how we say, is it gross misconduct, but under what circumstances? What is the caveat to that? It's just a minefield, I find. The more you think about it, it's too frightening. But in the
I think it's because we don't know enough about it, do we? We don't know what AI tools could be useful to a disabled person, depending on what their disability is. If it's communication based or neurodiversity and all of those kind of things. That's very difficult to somebody who uses AI because they have a sight defect, which, so there's all sorts of kind of other transcription. We had a blind lady that worked at the company when I was in-house a few years ago. And she had she had some software that would enable her to communicate with people. Obviously that would probably be some sort of AI software now, but it was very basic back in the day. So we just don't know enough about what's available, I suppose, to help people, and they're probably the experts because they know what they would benefit from, and they may have done their own research, or part of the the communities that they're in, for example, might have shared lots of information, or I don't know. It's just a bit of an unknown. I think that's the problem.
Yeah, I agree. I was just thinking, I think that's the biggest thing right now, isn't it? Is we're all desperately trying to catch up with what's already been rolled out and is in place, and everyone's trying to figure everything out, and that's quite a scary place to be, I think, when it's a huge area and it overlaps with so many aspects. And GDPR is obviously a huge part of that. And I was just thinking about some of my clients where even when GDPR kind of came in, it caused a huge amount of, upheaval for people to think, well, I don't even know really what I do with the data that comes into my workplace, and then I've got to tell people what I do with it. And I think it's like it's another not a repeat of that, but it's very similar in tone as to everyone's got to really work out what they're doing and how they're doing it and why they're doing it, and what they're going to do with that information. So I think it's caused a lot of concern. I think a lot of people have sort of thought, you know what, I'm just going to see how things play out. I'm not going to be proactive. And then, like you said, Gemma, some companies have been very proactive about it, which is great. But I think the majority are trying to see how things work. But then we're all on the back foot in some ways. And I think we're crying out for legislation to come in to kind of define certain things, to explain what's required, and obviously all the guidance that comes with that. It's really critical, I think, now, because we can't sort of sit and wait for much longer. I don't think it's causing it, and it will do. It will just get bigger in scope. So that's my sort of take on it at the moment.
God,
Scott.
Natasha, you know what everything you just said, I had this parallel analogy to when the pandemic kicked off, and it was just such a parallel to that, because it's very much like that, being proactive and having legislation and proper guidance. But in the interim, just literally trying to figure it out on our own.
Yeah. The other, I just think it's just education, isn't it, really? We need to be educated about it, and have some guidance as to what is required, because I think employers are going to fall foul of lots of areas if we don't have that in place. I did read the other day that there was an ET case with Uber Eats. I don't know if anyone is familiar. I hadn't actually heard about it. I was just looking up a few things the other day. It settled out of court in the end, but it was a facial recognition case where a food delivery driver
I
was
think I remember this.
Oh,
Yeah.
yes, I do. Food,
Yeah,
yes.
race discrimination, because he
Yes,
the app was going, no, you're not being recognised, so you can't take on the work. And obviously that was then having an impact on him earning an income and everything. And I thought that was really interesting, because you kind of think, like, face recognition and biometrics, fingerprint stuff, it's all quite useful in lots of ways, isn't it? But if it doesn't work properly, then the problems that can cause are huge, actually. And it was saying that
I think the
technology behind it, because nobody really understood it.
the facial recognition, I think, is quite it has a lot of potential for problems, and I remember reading a bit about it, how it's got sort of a lot of mechanisms being used by companies have sort of inherent bias. But in particular, I remember thinking about neurodivergent people with the lack of eye contact in recruitment, if they're using that kind of mechanism, because it's often looking at eye contact and that kind of thing at the screen, which people may not feel comfortable doing. So yeah, I think it's a minefield. I think it's quite unsafe from employment law perspectives with the facial recognition, for a number of reasons.
We need to locate an AI expert who deals with employment law and HR. Sandhya, find them.
Yes.
I don't think I know. Tell me about it. This is why I brought this discussion here, because I think you're right. We're really lacking one who's a nice crossover with the two. It's got to be somebody who totally, because in the US, I find, so my friends who obviously work and live in the US and who are in HR professions, they are way ahead of us. But I'm talking about big corporates, and it's just not something that you can transfer across into where we are working, and with UK laws, as we all know, the US employment law is, it's a world of its own making, but we can't just apply that here. So we really need somebody who understands AI and everything it can do or achieve, and the pitfalls, and how that would tie in with UK employment law.
Anyone know one?
It's anyone know one, yeah.
If anybody's familiar with the HR Ninjas Facebook page, it's a very useful resource at times, although it can get slightly argumentative when people start back and forth and disagree with each other. But within that, there has been some kind of webinars about AI for HR, and unfortunately I missed the one that was for HR specifically, typically. And I saw the one about just general kind of AI for business. So they may do something in the future about it. So it could be useful.
There's been a couple on the CIPD, I think. Didn't Pam Lock do one not that long ago?
Yeah, possibly.
I'm trying to think. I got kicked
remember.
out the HR Ninjas because I didn't follow the rules or something, because you have to be truly I can't remember what it is. Is it that you have to be truly independent, or
you're supposed to be
or you're meant to be
in-house?
in-house? Yeah, that was it. I knew it went one way or the other. So because I'm not in-house, I got kicked out.
They haven't spotted me yet. But I joined ages ago when
Keep your head
was
down.
not, when she still wanted lots and lots of people to join. So she's obviously, maybe I'll get kicked out in the end, but
Yeah.
I'll keep my eyes open anyway if I hear anything.
Yeah, please,
I'll share
definitely.
it.
And Rose, definitely, I think we need to bring that person here at the round table to have a chat with us. Just so we can all heave a sigh of relief, saying, okay, this is where we go to if you have any questions.
Yeah.
But I've just posted some information on that case law that Natasha was talking about. It's just there on Personal today, so that came up, yes, but I don't recollect reading it. Very interesting. Anything else? Chris, you've been very quiet.
Yes, deliberately so. I thought I probably articulated a little bit too much at the beginning, so I thought I'd stand back and let everybody else get a look in. I thought you'd probably heard enough, but I've been following everything you've been saying. It's very interesting. I had looked at was looking at the House of Commons library notes, and they were talking about algorithmic management, use of AI in recruitment, job adverts, sourcing candidates, filtering CVs, task allocation, performance management, surveillance monitoring, workforce, and talking about common law developments, because employers, based on trust and confidence, employers need to be able to explain decisions, and equalities law and inherent bias, which all of which you've been talking about, privacy and sort of human rights and guarantees to privacy, data protection, processing privacy statements and so forth, and then the policy development, switching from the sort of Tory approach, which was very laissez-faire, to the Labour approach, which I think will be more interventionist. So I've been sitting here nodding away. Don't worry. I think everybody's comments have been actually spot on. There's a huge overlap, isn't there, across all our fields, and it is interesting because I joined my firm in the age of the dinosaurs, and I bet you I would have written my CV or my letter of application with a couple of precedents in front of me. I would have been sensible to have had a dictionary thesaurus out. More latterly, I would have had Google in front of me. And, if you're talking about tools and the adaptation of tools, AI is simply an adjunct of that, isn't it? And therefore it's rather difficult to start bringing connotations of fraud, because it's the misuse of AI rather than the correct initiative and adaptation of it, which I suspect is where people get into hot water if you're fraudulently representing skills or experience that you don't have, as opposed to trying to present your case in the strongest possible way, because it seems to me that that's all part of development and evolution, and anybody sensible looks at something in front of them, because as you say, you sort of adapt what and improve upon. So I think the whole field is terribly fraught with difficulties, but it's coming, isn't it? I mean, there's no there will be redeployments, there will be job displacements. You know, there will need to be checks and boundaries put in place. You know, I don't know where it's going to go, but I can see it's going to go.
Yeah. Yeah, I think the fear is more because they're so way ahead of the game in the US already, and here we are starting to accept it now that it's well and truly a part and parcel of day-to-day work life. But like Natasha rightly called out, there is just no structure to it. There's no framework. There's no there's no definition. And like I have just pointed out, one can draft a policy, but which would be fine in a certain circumstance, but once you bring the disability angle into it, you can fall foul of your own policies. You know, what you're referring to as fraud in one context may not be fraud at all in another context when you're looking at disability, you know. So it's really tricky, very tricky.
Yeah.
But I'm so glad we have this round table. At least we can bounce ideas off.
Yeah, we're all in the same boat.
Yeah.
I really am. I'm really grateful for this. So no, thank you so much. Anything else that anybody would like to add? If not, I don't have any problems wrapping up. I know it's 8, we've got 8 minutes left. Gosh, the next one is going to be November, which is going to be quite close to Christmas. I really cannot believe this, but anyway, here we are. I will keep an eye out, Roz, like I said, to have another guest speaker come in who specializes in AI and understands law, but I will think of another topic in the meantime. Yeah, and if you want anything specific, any burning topics or questions even, please send it over and we can talk. Or even if you come across something that you find is really interesting and would be nice for all of us to know about, then please definitely pop us a note and I'll share that
Sandhya, is it worth
yes,
having a
sorry.
discussion at the next meeting about, because obviously in the next, well, what are they down to, about 16 days, 15 days?
Yeah. I'm
I'd
sure.
say the same.
Legislation potentially coming our way. So,
I'm
you know,
sure.
we might
Yeah,
have some
that'll be-
guidance as to what that actually looks like. And obviously
Absolutely.
guidance coming on the workplace harassment legislation. So there's quite a lot coming in. It might be good to just have an open discussion on what the implications are of whatever Labour have come up with in the next couple of weeks.
Yeah, definitely. I was just thinking maybe we just need to sit with a glass of wine, and due to that, maybe this meeting needs to be held in the evening rather than
Sounds
at
perfect.
10:30 in the morning.
Sounds good.
Yeah.
I think Christmas gives us a good excuse to do that. So maybe I'll try and push it to the evening. I don't know, but let's see. I'll have a look and see what dates work for everyone.
Okay.
All right.
Okay.
But
Thank you.
Thank you very much, and I'll see you soon. Anyway, I'll see you at networking before that. Anyway.
Thanks very much, Sandhya.
Thanks,
so
Sandhya.
much.
Thank
Take
you.
care.
See you.
Bye.
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 Bye.